Hello, my name is David Miller. I am a trustee in the United States bankruptcy system appointed by the Department of Justice as a Chapter 7 trustee to conduct creditor meetings. And so what I'm doing today is giving a brief demonstration of how those proceed so that someone who is going to have a creditor meeting, if they wish to know what it's like, this is a demonstration. What happens is the court sends notice to folks, creditors and debtors alike, that there has been a bankruptcy filed and that a meeting of creditors will be held. When I'm appointed as the trustee for a group of meetings of creditors, there may be 6 or 8 of them per hour, and we may have several hours of them. If you have one of those, then at the beginning of the hour, this is essentially what I would do. Good morning. My name is David Miller. I am the interim trustee appointed to conduct the creditor meetings for this 8 o'clock hour on this X day of the month. Are there any qualified creditors present who want to elect a different permanent trustee? Seeing none, then I will serve as the permanent trustee in each of the cases that are set on this 8 o'clock hour. There is no bankruptcy judge present. The law simply requires that a trustee examine each debtor under oath and give creditors that same opportunity. Before I continue, I'll explain the process. And the process is when it is your turn, you will take yourself off of mute and raise your right hand, take an oath, and then tell me your full name. Your attorney, if you have one, will then identify himself or herself, and I'll ask some other questions. But first, I have you testify that you are in fact the person whose name and address appear on the petition in this bankruptcy case. And then I look at the documents that you have uploaded to the Blue Stylus platform on my software to make sure that the image I'm seeing of you on the Zoom screen matches the photo ID of the driver's license that you have provided. And likewise that the Social Security card or other evidence of Social Security number matches. When I am done with that, I ask a number of routine questions. One of those is whether you read and understood the bankruptcy information sheet. You need to understand from that the different kinds of bankruptcy that might be available, such as a Chapter 13, the effect of a discharge, and the effect of reaffirming a debt. If you don't understand or remember that, you need to talk to your attorney. And I then ask you about your tax returns. If you have any returns that have not been filed, you need to file them now and provide a copy to me. And if you're expecting refunds, those are not generally yours, but are property of the estate that you surrender to me. By now, you should have also filed a statement of intent declaring what you plan to do with property that is collateral or security for a loan, like an automobile vehicle loan or a mortgage. And as your trustee, I simply direct that you do what you said you intended timely, surrendering the property to the creditor who has a lien against it, or making arrangements to pay and satisfy the secured obligation. If you object to the directives I give, you need to file your objections with the Federal Bankruptcy Court in either Salt Lake City or Cheyenne, depending which jurisdiction I'm working under. Send me notice of that and obtain a hearing and send me notice of that within the next 14 days. And generally for these cases, the deadline for objections regarding discharge is 60 days from today's creditor meeting, 30 days for objections regarding exemptions. And parties who are interested in objecting to or considering either the question of discharge or exemption should consult their own legal counsel and not rely on what I as a trustee do. If as a Chapter 7 debtor you want to receive a discharge, there are continuing obligations. You must notify the court of any change in your address, continue to cooperate with the court and with me as trustee, timely file evidence that you completed the second class, and follow through with any other obligations you have. If you don't do that, you may not receive a discharge, or it may be revoked, or you may subject yourselves even to possible criminal penalties. If you have any questions during the processing of your bankruptcy case, please call your attorney and not my office. I cannot give any legal advice. After giving that introduction, then I would trigger the tape recording. No one's allowed to record anything from the Zoom 341 meetings except me. And I would then start with the first track and call the first individual and go through that process. I hope that's helpful so that perhaps you can feel a little bit more confident about how the process may happen. Good luck.